Welcome to the show. I am your host, Daniel, and today is Judge Raquel. I can't even say her name, Raquel West. Judge Raquel West. So let me share my screen. Let me make this bigger. Why is it so small? All right. I'm going to mute my mic. I'm still going to be watching.
Good morning. Are you Federico Ortiz?
Yes, ma'am.
And will your client waive the formal reading of the motion and the indictment?
He will.
Mr. Ortiz, in cause number 25, DCCR 0589, you're charged with the state jail felony offense of abandoning or endangering a child, and that's from December 1st of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In that case, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Ortiz is not competent?
No, Your Honor.
All right, sir. In that case, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, in cause number, let me find it, 24, DCCR 2334, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 10th of 2025 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department for the months of May and June of 2025, and then also July of 2025. Is that true or not true? And then count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
True.
Then count 3 alleges that you failed to provide verification of completing the theft prevention class as ordered. Is that true or not true?
True.
And then finally, count 4 alleges that you're behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
I also have here on the tablet, in this case, some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over this with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes.
State tenders number 1.
No objection.
It's admitted. Mr. Ortiz, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, I'm handing you the trial court certifications that shows that there are agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you.
And thank you, Mr. Rojas.
Randolph Vines, Mr. Rojas. Mr. Rojas is getting a gold star this morning.
It's been a while since I had one of
Rusty star.
those. Luke deserves to have to put out. Most of these cases are yours.
True.
Oh, well, y'all might have to share a star, huh?
Sure.
I don't require
I'll take the whole thing.
It's always nice to get a gold star. Good morning. Are you Randolph Vines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Vines, at cause number 25 DCCR 1154, the state has elected to proceed on count one only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon, sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but lead to charges against you. If you have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the bailiff.
Your Honor.
That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've read it, I've said it so many times. But I can't stop in the middle and then restart. That's not good. Lamone Yeoman, Mr. Rojas. Give me just a second. I'm going to print these out. They're both MTRPs. It's just easier to find me. 19. Good morning. Are you Lamone Yeoman Jr.?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Let me get 'em. I should have another one coming also.
Yes, ma'am.
You're going to-
Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building. And that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true?
Portion.
It's true.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
Not true.
Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025, and is that true or not true?
True.
Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025, and is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025. And is that true or not true?
Not true.
All right. Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So,
It is a cap of 8 on 19-32846, and a cap of 2-year state jail on 23 DCCR 1556.
well, it's set, hold on. Anna, can you send me back 23-1556? I just sent it.
That may be the third degree paperwork. I think he may be right.
Yeah. Okay. I think, so 23-1556 is the burglary of a building,
Every state.
but y'all did TDC paperwork. And the other one, yeah. So those have to be right. So
We can read them.
I'm going to delete both of those.
That's fine, Judge.
I'll just hold this. We'll continue the hearing. I'm not going to go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did, there was,
I got the numbers wrong. We did them.
Okay,
I'll have to redo them both.
sorry.
That's my fault.
All right, I'm going to delete both of those. All right, y'all just go have a seat in the jury box and we'll get that done. Let me delete that. It started, I was looking and I was like, wait a minute, that's, because I thought it was a cap of 2 on the TDC case. I'm like, what? Okay,
Yeah, I forgot they were different levels. Luke caught the mistake. I thought they were different levels.
okay.
Do you want to plead Hendricks now, or do you want to do them when we do the other guy?
Go ahead and get that one done, and that way I don't keep this over here and get confused for too long, and I'll take care of a couple other things. Let's see. Mr. Kimler, you have Sheena Harmon.
yes, sir. Judge, if I can, there's a lot of family members here on the side too.
Yeah,
with
which
Marvin.
one?
It's Christopher James.
Okay, I'll take care of it next.
Thank you.
Would y'all put that Christopher James sentencing up here for me to do next, please? Thank you. Ms. Malfino on Colton Armstrong with Mr. Kimler. Is it yours?
This is
Harmon.
This is
What did
Harmon.
I?
You call
This
it
is
Harmon.
Harmon.
Oh, that's why never mind. Just testing everyone. Okay. Gosh, I feel like Monday. All right, are you Sheena Harmon?
Yes, ma'am.
Not Colton Armstrong? Are you sure?
Yes, ma'am.
Okay. And will your client waive the formal reading of the indictment?
So,
Okay, we're going on all of the counts.
Whatever
Or
makes
at
it
least-
third.
Okay,
Whatever
got it.
gets us to the judge.
Okay, I got it.
I think we're gonna need all of them to get us to it.
Okay. Ms. Harmon, in clause number 25, DCCR 0649, you're charged with the state jail felony offense of tampering with electronic monitoring device, and that's from April 30th of 2025. The indictment alleges that you were previously convicted of the state jail felony offense of theft June 28th of 2010, and then you were also convicted of the state jail felony offense of theft on June 24th of 2013, and on that same date, the state jail felony offense of possession of a controlled substance. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Harmon is not competent?
There is none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find those prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with electronic monitoring device, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler.
Yes,
All right, good luck to you, ma'am. You can go back with the bailiff. I thought I printed, my printing thing is being, okay. Let's see, let me take care of Mr. Armstrong real quick, and then I'll take care of that sentencing. Colton Armstrong, Mr. Kimler.
We're putting this as a third degree.
Thank you.
He's gonna have to plead true to anything else. I guess there's some first.
No, I'm
I mean, just here.
Good morning, are you Colton Armstrong?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
So, one, two.
Mr. Armstrong, in cause number 25, DCCR 0002, you're charged with the state jail felony offense of theft of property from February 21st of 2024. Your indictment alleges that you were previously convicted of the state jail felony offense of driving while intoxicated with a child passenger, October 31st of 2022, 2 cases on that same date of that same offense, making this a third-degree felony punishment range. And how do you plead to that charge?
Guilty.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would not be a fine, but you would be ordered to pay restitution in the amount of $20,000. Is that your understanding?
Yes, ma'am.
Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Armstrong is not competent?
There's none, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Ms. Malfino, what's the state's position with regard to bond?
Judge, may I just put one thing on the record first before that?
We're gonna come back for some.
Obviously, I was a little bit hesitant to make this offer based on those priors, and I just want Mr. Armstrong to be aware, I have relayed this through his attorney, that if he does not pay this restitution back, I won't be asking for the minimum that I offered him today, 15 months. I'm gonna ask for 10 years based on the opportunity that he's been given. I don't know that he doesn't have a hold in Hardin County. And I'm not saying that disrespectfully, I just want him to be aware of what he's just gotten himself into if
Sure.
the court follows the PSI. So I don't know if he has any holds.
I believe he does.
I'm a little hesitant to allow him on bond before you review the PSI, but I'll defer to what you think.
It sounds like based on that, and there is a hold from another
I
county.
can't say that they put a hold on him. I don't know. I know he has pending cases in Hardin County. I can't speak to whether there's a detainer on him from Hardin
And I've
County.
tried to reach out to Mr. Hopper over there and not that much.
Join the club.
Bruce.
He does have a pregnant wife, Your Honor, that's due fairly soon.
31 weeks, right?
31 weeks. Almost said 31 months.
Oh my gosh, wouldn't that
Feels
be?
like it.
It does.
I wouldn't know. I think the two, he has an unauthorized use of another vehicle, and then a theft of the same vehicle, but in Hardin County.
He does have 2 Hardin County holds.
So those would have to be cleared as well.
Yeah, and by the time, I'm afraid if I set a bond and then they get them over here, then we're not going to get the PSI. It's just going to prolong everything. And I think I'd rather go ahead. I'm not going to adjust the bond at this time. Let's get it taken care of. And then as soon as sentencing gets here, if everything goes well, you'll be released, at least from our custody. And then you can go take care of your Hardin County cases. All right, you can go back with the bailiff.
Thank you.
Thank you.
Thank you. Who's crying? I haven't even done anything to, I haven't even been that mean yet today. I'm about to. I would probably be too. Mr. Lewis, Christopher James, Mr. Mr. Nichols.
Christopher James.
Good morning. Are you Christopher James?
Yes, ma'am.
And Mr. James was previously in court, entered a plea of guilty to the first-degree felony offense of intoxication manslaughter with a vehicle. I've received the pre-sentence report and also a supplemental memorandum from probation that includes several letters from the victim's family members. Has everyone had an opportunity to review all of that?
Yes, we have, Your Honor.
Are there any additions or corrections to that pre-sentence report?
No, Your Honor, I just want to make the court aware, Mrs. Addison, the deceased's wife, would have been here today to do victim impact. She had to go to the hospital yesterday. She's able to tune in, I believe, and watch us. The rest of Mr. Addison's family is here, and his mother is going to want to do victim impact at the end of sentencing.
Okay, thank you, Mr. Nichols. Any witnesses with regard to sentencing?
No additional witnesses, Your Honor.
All right, Mr. Lewis, you may make argument.
Okay. Judge, of course, this was a very tragic situation that has affected a lot of people. Of course, the decedent, Mr. Addison, his family, as well as Mr. James and his family. It was a situation where, this was a combination of a long substance abuse history of Mr. James. The assessment that's provided in the PSI here says that there was about a 20-year relationship between Mr. James and different substances over a period of time. We have, the one thing I can say is that once Mr. James went through this situation with his accident, he has been doing everything he can to try to better himself. He has got his high school diploma. He's was baptized and has definitely changed his ways and going to his faith and continuing in that regard. He's also got some different certifications that he was able to receive dealing with OSHA, I think it was Men's University, things of that nature to try to better himself, Judge. Now, it's no secret he does have a long criminal history. That even included dealing with PCP, which is the same substance that was involved in his accident. And as well as, other serious offenses. I do want to address something as far as, I know there's some situations here dealing with the jail instances, and I know how the court proceeds or looks at the situation here dealing with those. Mr. James, if you look at these situations, majority of them did come from situations involving him and other inmates, as far as any type of fight or anything like that, which unfortunately some things he can't avoid. But as far as anything dealing with being disrespectful or anything towards jail employees or things of that nature, there's one situation I think that they were talking about that it wasn't an actual write-up, but it was notated. He has been a trustee over there for a period of time at the jail as well. Now, I do want to point out that, of course, some of those situations that Mr. James was able to do to better himself, of course, could definitely increase his earning potential as far as what he has, as far as his job situation. He does have significant family support. His brother is here today in the courtroom, who in any way is there to try to help him, including helping secure employment. My understanding is the plan, once he is able to be released, is for him to be moved to Houston, Harris County area, to be close to his brother, to help him with everything over there. Now, PSI did have a recommendation for his different vehicles that support that's available to him through the probation department. What I will say is that everything that has been recommended, he definitely needs and will be better for him. We are not, and ourselves, are not asking for a specific number or anything like that. We just want him to be able to, of course, make amends for this situation as much as possible, which could include some of the restitution there. I think is the amount is over $100,000 for his restitution there to the family. Now, like I said, he has made a plan to try to better himself. He has a family that supports him. He is doing everything he can. He understands that this was a tragic accident, but one he was definitely responsible for. And what we're asking for is as much leniency as possible from the court, for him to be able to move forward with the situation, be able to make amends as much as possible. And I think he did provide a letter to the court as well to kind of speak to that, as far as an apology letter that was to the family, his family, the family of the victim, as well as to the court, Judge.
And I've received that.
And so that's what we're asking for today, Judge, is for everything to be considered. We understand this is, you can't bring that person back. You can't just go back to make amends with Mr. Addison. But he wants to try to make as much of amends as he can to society and do better going forward, Judge.
Thank you, Mr. Lewis. Mr. Nichols?
Your Honor, I think any consideration to Mr. James's due was given when he got a 50-year cap. I have no hesitation asking the court to exercise the full 50 years. This case is one of the worst intoxication manslaughters. It's on video where he plows into Mr. Addison, who's at a stoplight on a motorcycle, and while trying to get away, runs over him and the motorcycle again. It's horrific, Your Honor. What is also just inconceivable to me is that a man who's on parole for several possessions of phencyclidine, PCP, finds himself behind the wheel on PCP again. And this time it ends in the death of somebody. His criminal history is extensive. It starts with minor drug offenses, then a conviction for aggravated robbery, and then I believe it's 5 drug convictions all at the same time in 2020, for which he was quickly paroled out and on parole when this happened. The fact that he gets to make plans in his mind for a day he's set free, I find rather offensive, and I think the Addison family finds offensive. They lost a son, a brother, a husband. There's nothing we can do in this courtroom makes that better. And sometimes the justice system is a poor substitute for what people lost. I think the best we can do at this point is this man spend 50 years in prison where he cannot hurt anybody else due to his own selfish decisions and continued use of substances. It's in the pre-sentence report. He minimizes his own addiction, his own dependency. He even claimed he did not know how he could have gotten PCP in his system the day this happened, that maybe he touched a bottle and it transferred through his skin. And I find that reprehensible, Your Honor. And that's why I'm asking the court for that full 50 years.
All right, thank you. So, Mr. James, a couple of things that Mr. Nichols didn't say that I think are also extremely important is this isn't your first driving while intoxicated. This is your third. And so you didn't learn in 2006. You didn't learn in 2017. 2017, you got your second DWI. You were given probation. It was revoked. I appreciate that you entered a plea of guilty because for myself and for the family, I'm glad we didn't have to see what it looks like this would look like on a video because it is just horrible. And the fact that you are truly saying that you think you touched something and got PCP when you have had PCP cases over and over and over again, and you're on parole for possession of a controlled substance and you kill someone. It's a nightmare. Sure, go ahead.
Can I say something? You know, that night that accident happened, I've been clean the entire time I was on parole. Okay, I stopped off at a friend's house to give him some advice about what he was doing. And during that time, I did contact a bottle of his. You know, I was not high at that time at all.
It was in your system.
Yes, ma'am. If you know how I fight you.
At this time, based on your history, based on the nature of this offense, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter. I'm going to sentence you to a term of 50 years in the institutional division of the Texas Department of Correction. There will be a deadly weapon finding based on the indictment alleges a deadly weapon. You will receive credit on this sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement and I followed it, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. There's really so many other things I could say about how horrible this is, and rarely am I out of words, but I really don't have the words to say what a tragic circumstances based on your behavior this led to. Y'all can have a seat at council table for the victim impact statement, and we'll go off the record. Do you want me to leave it on for the other family member to hear?
I think that would
If the
That's the sound of an American oil company. Hard
I have received from the state a couple of notebooks with letters of support and information. I have reviewed those. Have you had an opportunity to do that as well?
I have not, but we have no objection.
Okay, thank you.
I only want to confirm that the letters from my client's wife and children and his pastor, his church, and other church members were included in the PSI. They were included in my copy. I just want to make sure.
Yes,
And I saw those in the video.
they were, and I've reviewed those as well.
Thank you.
Okay.
Obviously, we're here for the sentencing of Mr. Gomez on these very serious charges. I want to point out some contextual evidence that came out through the investigation by the district attorney's office and by our office. But I want to be clear, this is not an attempt to excuse his behavior. It's not intended to do anything other than give the court some context that led to this particular tragedy. This entire thing began with a work-related gathering. Mr. Gomez had been in Beaumont only about a month, working for one of the construction pipeline companies, unfamiliar with the area. There was an invitation to go to these different restaurants and places by his supervisors. He felt compelled to go. The report by DPS highlights that they spoke to several witnesses who were co-workers who said this was kind of an after-work gathering where they all went. Of course, once the companies realized the magnitude of what had happened, next slide please, they quit cooperating. Basically, no one would talk to DPS, no one would talk to our investigators. They kind of circled the wagons. I think that lends some credence to the fact that this was something that the companies did encourage the employees to do. The entire matter was investigated by the Texas Alcohol and Beverage Commission. And the first place they went, go back please, was Darla's Taqueria here in town. And from the TABC report, which is introduced into evidence as part of the plea, next slide, they made a determination that Darla's Taqueria had grossly overserved Mr. Gomez, and that it was contrary to basically any public sense of decency. Next slide. The next place they went for the TABC report was Temptations Cabaret. The report details, next slide, the enormous number of drinks he was served, including one where he was served 5 shots at the table and seen to fall down by the waitress, and she still served the drinks at the table. They determined that they clearly overserved an intoxicated person. The big question here that I had when we began this case is, how did he end up going on the southbound on the northbound lane of 69? And he was staying at the time at the AAA RV Park, which is located down here on, I believe it's Old Port Arthur Road. And his route of travel would have taken him from Temptations Cabaret down through that, I believe exiting and going down Old Port Isabella Road. Next slide. Obviously, he missed that exit, and he came down, and there's another way that you can go down 69 southbound to likewise get back to the RV park, and that was his plan at the time. Next slide. The problem is, and soon after we looked at this and investigated it, and they had the GPS data from his phone, he exited, he turned down Martin Luther King, and he came to an area where he would have gotten on the ramp to go up to the southbound lanes of 69. But, next slide, there was this side, one more slide closer. Right there on the ramp, it said road closed. Now, I believe what they meant to say was lane closed, and they wanted you to go around that and get on 69. But when he was confronted with this road closed sign, he took a left, which is what the detour sign seemed to indicate, went down, and then got on the exit ramp for the northbound headed southbound. And it's common here, I've seen it in several places where they have divided what were one-way service roads into two ways, and he assumed that was what happened. Of course, that led him on to the southbound, going southbound and northbound. That's how he got there. Next one. Salvador Gomez, I want to congratulate the probation department here in Jefferson County. They did an incredible, very thorough, and I think very even-handed and fair pre-sentence report. But a little bit about who Salvador Gomez is that came out through the report. Next slide.
If you're a
He was a military veteran. He was served in the United States Marine Corps, was honorably discharged. Next slide. He's always worked. Graduated high school in 91. He attended the police academy in 1992. He was a deputy sheriff in Cameron County until he had an off-the-job injury where part of one of his fingers was amputated and he could no longer continue as a deputy sheriff. At the time of this, he was employed by ExxonMobil as a piping superintendent. He's been confined to a wheelchair since this incident. He's had tremendous injuries. He's going to suffer from those injuries probably for the rest of his life. Next slide. And as the PSI points out, that something we would ask the court to consider is that does reflect some personal consequence for his actions in this particular case. The PSI and everything we see indicates that he's a very stable, loving father and husband. He's been married since 2001 to the same woman. He has 4 children. He active in his church. There were several letters of support from his pastor and from other members of the congregation included in the PSI. Next one. The probation officer noted that he thinks of the victims daily. He knows their names and has a personal connection because one of them is in very close age to his own children and another shares the same birthday as his daughter. Those are things we'd like the court to consider from the PSI, and we'll have a closing argument later. Thank you.
Today calls Christopher Stack.
Good morning, sir. If you please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat.
You married?
I was.
When were you married?
About 1.5 years ago.
When was the last time that you heard from her?
I believe I fell asleep around probably 11 or 12.
And had she texted you at that point?
Yes, sir. The last text, I believe, was that she was coming home to see me soon and that she loved me.
In the early morning, June 14th of last year, did you realize something was wrong?
Yeah, I woke up and it was probably, I want to say 1:30 or so. I can't remember the timestamps, but I woke up and she hadn't texted for a while. I had a location on my phone.
And so at that point when you woke up, did you expect her to have been home by then?
Yes, sir.
Was that unusual for her to have been out that late with her friends?
Never.
You stated you could follow her location on your phone. Were you able to do that?
I was, but she had her in front of the prison or the jail for like an hour or so when I saw that. Maybe it was an hour, I can't remember for sure, but
it wasn't moving, was it?
It wasn't moving.
So what did you do?
I immediately threw clothes on and got on the road.
And you're driving from where?
From Beaumont.
As you got close, did you realize something bad had happened?
Yeah, so when I turned that curve going on 69, I saw a lot of,
You saw lights?
yeah, I saw the lights.
Chris, when you pulled up, could you tell there had been a car crash?
I knew there was something wrong.
Can you tell Judge what you did see when you pulled up?
I couldn't see much because it was, the median was in the way, but I turned around the underpass and I saw there was a cop that stopped me. I guess he was directing traffic. And I asked him, I said, has there been a wreck? He said, yeah. I said, my wife, her location was right there. And so he let me through. I drove through and I was stopped about probably 100 yards from the spot of the accident. And I couldn't remember exactly what was asked or what I said, but he basically told me, I showed him my phone, I showed him the location, and they couldn't even tell who it was or who was in the vehicle or anything, because the bodies were just...
There was a burning car at the scene, wasn't there?
Yeah.
And from that car, there were no survivors, were there?
Yeah, they took them, I believe they took them weeks to find out who it was.
But was it ultimately identified to be your wife?
Yes, sir.
Lauren Stacks?
Yes, sir. She was in the passenger seat.
This is a dumb question, Chris, and I'm sorry to ask it. What's this done to you?
It's affected me in every single aspect of my life.
How long has y'all been married before she did?
Only 19 days.
I'm sorry you have to be here, Chris. I'm sorry all these people that are in the courtroom have to be here. You and I spoke about this case, the legal side of it, and what can possibly happen. What are you asking Judge West to do today?
I think the only thing that can be done is the maximum sentence. I think that's the only way that any kind of healing can be done, from just on my end and from the 1,000 lives that were affected by this senseless tragedy.
Thank you, Chris. I'll pass it to Sharon.
Any questions? Thank you.
Never ever sue the other.
Back in June of 2024, were you engaged to be married?
Yes, sir, I was.
And who are you engaged to be married to?
Camille Marty.
And how did you meet Camille?
I met Camille right during COVID at a church conference in Sebastopol, Mississippi. She was from North Carolina. I was from Beaumont, Texas, so it was a pretty unlikely meetup, in the middle of nowhere, Sebastopol, Mississippi.
And I take it y'all hit it off.
We did. It's a hilarious story that I was in the altar in the worship service, and she was in the altar in the worship service, and we saw each other in the altar. And we probably made eye contact 20 times in the worship service in the altar. And after service, I made sure to say hi to her.
And at what point did y'all become engaged and married?
We got engaged in March of 2024.
And you are friends with Christopher Stacks, correct?
Yes, sir.
And y'all had this friendship, and both were starting your families together at the same time. Is that correct?
Yes.
How did you find out that Camille had been killed?
I was asleep, and my dad busted into my room, and it was about 4:30, 5 o'clock in the morning. And I remember waking up, and he just said, "The girl's got in an accident." And my first thought was that they had to be okay. There was no way something like that could happen. And I immediately asked, are they okay? What hospital are they at? You know, what ER are they in? And all my dad could say was, they didn't make it. And all I could say was no. Just no, no. And I jumped out of bed and I still just couldn't believe it. There's no way. And I got dressed as fast as I could and I ran downstairs and I didn't know what I could do. I thought there was something maybe I could do. And my dad just told me, he said, Bubba, there's nothing you can do. There's nowhere you can go. Can't do anything.
And since this has happened, how's it affected you, Boston?
I had begun building my life with Camille and my life plans and our life that we were building together and we had just begun to build together was just taking off. And the one thing that I thought I had done right in my life was deciding to marry Camille. And with that gone, I feel so lost in like this life that I was supposed to have, which has been taken away from me.
I'm asking the same question that I asked Chris. What do you want to see happen here today?
Full sentencing underneath the law, that's possible.
And that's actually not enough, is it? Nothing can fix it.
I don't believe it is.
I understand. Thank you, Mr. Carter. I'll pass it to you.
No question.
Thank you. Mr. Gomez, please, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. Just be sure and speak loudly and clearly into that microphone so everyone can hear you.
Yes. What have you been spending your time in jail doing?
But I've been trying to do whatever I can to get back physically, doing what I've done, like basically walking, a little bit of therapy. I mean, we don't have no therapy or nothing. But like out there in the civilian world, so I just do whatever I can.
Have you been talking to other prisoners?
Talking to other prisoners. I've been mentoring some prisoners there since I'm one of the oldest in my dorm, one of the few older people there in my dorm. So I've been mentoring some younger guys in there, helping them out with their troubles in life and stuff like that.
Did you, were you a member of a church before?
Yes, sir, I was. Solid Rock Church.
How long had you and your family been attending the church?
We've been going there for about 20 years.
So in other words, your faith wasn't a jailhouse conversion.
No, sir, it wasn't.
I want you to explain to the judge, why did you decide to plead guilty?
I decided to plead guilty because of my drinking that night. I caused this accident. There's no ifs, ands, or buts about it. I went down the wrong way, caused this tragedy. I can't say, I can't say much about it. I did it. I caused this accident. Caused the hurt to the families that are here. There's no other, I can't say nothing else. I was in the wrong. My drinking caused this. That's pretty much why.
You talked to me about things that you would hope to do with this tragedy. What are some of them?
Some of the things that I want to do is bring awareness, more awareness to the drinking and driving. Bring it out there, go to maybe high schools or something before they graduate. Talk to them, maybe partner with a MAD organization.
You've never been convicted of a felony anywhere, correct?
That is correct.
And so you technically qualified for probation. Are you asking this court for probation?
No, sir, I'm not. I don't think it's appropriate. I'm taking full responsibility for my actions.
Imagine being able to build an app with your name on it, just by thinking about it. Meet Base 44, a complete AI creation platform. Describe what you want, and watch it take shape. You can plan, customize, and expand in any direction. From tools built for one, to platforms ready for many. From passion projects to enterprise-grade systems. Everything is built in and ready to launch. It's a new world of creation, where you can go as far as your imagination takes you. Can you imagine it? Let's make your dream a reality, right now.
Is there anything you want to say to the families?
To the Eisenhower family, to the Marty family, Mr. Stacks, Mr. Carr. There's nothing that I can say, nothing that I can do to bring your loved ones back. Now, the remorse and the shamefulness that I feel about this is unthinkable. Nothing that has happened to me compares to the destruction that I've caused in your life. I've destroyed your life. Nothing that my injuries, that doesn't even compare. I can't even fathom what you all are going through. I really don't. And I've thought about this for over a year. And I just can't come up with a proper thing to say, but what I've said. I don't wish this upon even my worst enemies, because I know you all are hurting beyond imagination. And like I said, I wish I could do something, but I can't.
Have you asked for forgiveness from your personal Savior?
Yes, I have. I ask for forgiveness for my Lord and Savior Jesus Christ. And I'll have my judgment day with him one day. Trust me. I've said it to myself a bunch of times, and I've said it to him too. Why didn't you kill me instead of them? I would have preferred that. But I did what he did. And I'm sorry. I'm very sorry.
Thank you. Any questions, Mr. Nichols?
Yes, you are. How many DWI convictions did you have before this night?
3.
2 here in Texas and 1 in Virginia, is that correct?
That is correct.
And on those occasions, you were put on probation?
Yes, sir.
And as part of probation for DWI, I'm sure they taught you the risks involved in drinking and driving.
That is correct.
And you learned why it's so dangerous.
Yes, sir.
So you've been through this before. How old are your children?
27, 21, 20, and 18.
And if, God forbid, they were taken from you because of someone drunk, intoxicated driving, what would you be asking the judge to do?
I will let the justice system look at all the facts and the judge, and for her to decide, or them to decide what is the right thing to do, the right decision.
When you were taking shots at the strip club and stumbling over your chair, what was going through your mind at that point?
Not a whole lot.
And then after that, you decided to get in your truck and drive 20, 30 miles back to where you live off of Westport off the road. Correct?
Yes, sir.
And your evening started at the Taqueria in Port Arthur,
Yes, sir.
where you drank 8, 9 beers between 5:30 and 9:30. Is that accurate?
Yes, sir, I think so.
And you left the city of Port Arthur after having had 8 or 9 beers and drove the 30 minutes or so to a strip club in Beaumont. Is that accurate?
Yes, sir.
And for several more hours, you continued to drink. You took shots and you drank beers.
Yes, sir.
And then after about 12:30, 12:45 in the morning, you got in your truck to drive back to West Port Arthur Road.
Yes, sir.
And you're asking this court to give you some mercy for your choices.
Sir, I'm asking the courts to review the facts. And the judicial system, they can make the right decision on what they want to do, sir.
I'm sure they can. Pass, please.
Anything else, Mr. Young?
One question. Mr. Nichols referred to your prior offenses, the misdemeanor of driving while intoxicated. When was the last one?
In 2005.
Pass.
Anything
No
else?
question, sir.
All right, thank you. You can step down. Mr. Young, you may make argument.
This is an oil port surrounded by ruins where survivors gather.
Your Honor, my client recognizes the profound loss that he has caused. And if this was nothing more than about an expression of that loss and devastation on the Eisenhower and the Marty family, it's an easy decision. Just like the state is going to ask for it, just like Mr. Carr asked for it, the maximum. But this court knows that our criminal justice system requires that we look at more factors than that. Because our criminal justice system is about more than punishment or an expression of loss and devastation. This court has a difficult job because you have to distance yourself from, I know, what we all personally witnessed and felt hearing that testimony. The pain that we saw. It's difficult, but our criminal justice system says we have to look at different things. And so what are the things I would ask this court to look at? My client's acceptance of responsibility. He has never once intimated to this court he was not guilty. We were discussing who should do the punishment since day one. He has always wanted to accept responsibility for his actions on that day. And I can tell you from speaking to him, and I think it came through the stand, since I first met him, he has been extremely remorseful about you. He didn't want to talk about the impact on his family, who's present here in court, his wife, his children. Because he knows, he told me, don't put them on the stand, because whatever they're suffering is nothing compared to what the Eisenhower and the Marty family is suffering. He understands he's going to prison. That's what's going to happen. It's what has to happen. But he does want to try to do something with this. And as became clear, and it's clear in the PSI, religion has been a big part of his life, and his children's lives, and his family's life. He didn't ask the Eisenhower and Marty family for forgiveness because he knows he can't forgive himself. And he knows there'll be other things that he'll have to answer for in the future. I wanted the court to be aware of some of the factors that led to this. Not because they excuse in any way Mr. Gomez's behavior, nor does he want the court to think excuses his behavior. But to ignore those factors in doing this, two establishments that grossly overserved an intoxicated person, violating the law, violating their commitment to their patrons and to the citizens of Jefferson County, that has to be considered. The ongoing, never-ending, incredibly confusing signage construction that doesn't seem to make any progress only continues to put people, those are things that could cause not simply an intoxicated person, but any of us to end up in that situation going the wrong way. To ignore those factors, excuses, endorses, and will not change anything about those things that are impacting the community. We trust that this court is going to impose a sentence that's fair and just upon us. Thank you.
Thank you. Mr. Nichols?
Thank you, Your Honor. Judge, you heard how these crimes have ripped two young families apart, ripped a community apart. And yes, as devastated Mr. Gomez's family as well. But they get to see him. They get to visit him. And at some point, he may be released. I'll submit to the court the physical evidence in this case would have been horrendous. And I'm glad we did not have to have the family sit through that. But the magnitude of this crimes, and the loss they caused, I think, calls for the maximum sentence allowable under law, Your Honor. Each case is punishable by 2 to 20 years. Under the provisions of Penal Code Section 303B1A, the court can run those consecutively, stacked on top of each other. That is what I'm asking the court to do. 2 maximum sentences with deadly weapon findings stacked on top of each other, along with a maximum sentence in his third case, the felony DWI, which doesn't really affect anything at the end of the day. 20 plus 20 is 40, and that's really not enough, but that is the maximum allowed under law, and that's what I'm asking you to do on behalf of the Marty family, the Eisenhower family, Christopher Stacks, Boston Carr, and their entire faith community. The one reason all these people, including the Gomez family, are here in this courtroom today is because of what he did, what he chose to do. And it is a tragedy up and down. And so I'm asking you to protect the citizens of Jefferson County from any chance that this can ever happen again from Mr. Gomez.
Hello, my name is Adam Ferrari, and I'm the
Thank you.
Thank you. First, I really do want to thank everybody for being here. We don't have full courtrooms like this. Just as both of the attorneys said, these are some of the most difficult cases that any judge has to deal with for many reasons, obviously. Mr. Gomez, had you been in, well, I'm not sure that it would matter, but had you been in here and this was your first DWI, there might be some sense of what your attorney was asking for me, which is true. I mean, I have to detach myself from the emotional part, which is, it's impossible, but it's required, and I do the best I can to do that. And there are things about you and your life in the past that are good. There are things that the 3 prior DWIs should have taught you. Your age, you're 52 now, 53 now. The 3 DWIs previously, even though they're older, and your age, it's not the establishment's fault. Did they violate the law? Absolutely. You're a grown man. Grown man. Got into a vehicle, and I think it was underrepresented by Mr. Nichols from what I read that there was at least 12 beers at the first place. And then you drive. I guess we're lucky in some ways you didn't get whatever family was on the road going that direction. And then go falling over yourself at 50-something years old. You know at that point, you know you shouldn't be in a vehicle. You know from your history, you know from your age, you know probably from telling your own children not to drink and drive and trying to probably instill that in them. And you did it, and you did this. 24 DCCR 1651. I'm going to find you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. I'm going to sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. I am basing that on all of the information that's presented in both the pre-sentence report, the attached reports from the officers, in addition to the letters from Mr. Stacks, who unfortunately had to drive up and see this in person, from what they had to use to identify these two precious young lives, that there's no way that there is any doubt that you used your vehicle in a manner capable of causing death, and that you in fact did that. In cause number 24 DCCR 1652, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. Sentence you to a term of 20 years. There will also be a deadly finding in that case based on the same information and evidence that I used in the previous one. That sentence will run consecutively to cause number 24 DCCR 1651. In cause number 24 DCCR 1653, I'm also going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more. Find those prior offenses true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. That will run concurrently with the other two sentences. You will receive credit on these sentences for any time that you've been in custody that the law gives you the right to receive. You will be handed in a few minutes the trial court certification that shows that there were not agreements in this case. You do have some rights to appeal. You can talk to your attorney about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Firearm is a legal term. You should read that document that I provide you. If you have questions about that, you can also talk to Mr. Young about that. Mr. Young made a great argument on your behalf, but ultimately there's no getting past your history, your age, and the consequences of what those choices were. I'm sorry to your family for what you did to them. I'm more sorry to the other families for what you did to them as well.
Welcome to a destination.
Good morning, sir. Are you Michael Barelick?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Will, Your Honor.
All right, folks, buckle up, because this courtroom session moves fast. We've got 3 defendants, 3 completely different outcomes, and 1 no-nonsense judge laying it all out. First up, Michael B., charged with theft, gets a reduced deal, a lesser-included misdemeanor. Then, right after that, we switch gears to a probation hearing where things get real for a repeat DWI offender. And finally,
Proceed on the lesser included offense of a Class A misdemeanor theft of property from June 24th of 2024. And how do you plead to that charge?
Guilty.
when you hear the words lesser-included offense, it means the prosecution's cutting the bigger charge down. Kind of like saying, we'll take the smaller win if you plead guilty now. The judge double-checks everything. Was the plea voluntary? Did the lawyer explain it? Does he understand he can't appeal later? This isn't just formality. It's the system making sure there's no pressure, no confusion. For Michael, it's 180 days in county jail. Quick, clean, and legally airtight.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Barelick is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the Class A misdemeanor theft of property. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. Good morning. You're Juan Sanchez? And Mr. Sanchez is on probation in cause number 1830854 for the offense of driving while intoxicated, third or more.
Now we shift gears. Enter Juan Sanchez, a man on probation for his third DWI or more. He's already admitted to violations, but this time, there's no plea deal. The judge's decision will decide whether he walks free or goes back to prison. Both sides have reviewed the pre-sentence report, which means this isn't about guilt anymore. It's about how bad the violations were and whether he deserves another chance. This part of court is all about balance. Mercy versus public safety.
Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation. And there was an unagreed, there was no deal, and I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
And I have received some objections filed, comment and objections filed by Mr. Franklin. Mr. Nichols, does the state have any objections or corrections to the updated report?
Not to the report, Your Honor.
Okay. And so with regard to Mr. Franklin, specifically, with regard to number 1, that comment in there by the probation officer with regard to that it's unlikely that it was the first time, I'm not really going to take that into serious consideration. So that's not something that's going to make a big difference in what I do today or not do. So that one.
Here's where it gets tricky. The defense claims the probation report had a biased note, asking if a naturalized citizen could be denaturalized because of his record. They call it racial bias, but the judge doesn't buy it. She says it doesn't affect her decision. Then there's the big legal debate. Should old convictions from years ago still count? The judge overrules that too, saying she needs the full history to see patterns. Basically, she's saying, your past doesn't vanish just because it's old.
I guess it's an objection that can be granted. With regard to number 2, which has to do with a note in the records that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on their criminal history could still be potentially denaturalized and deported, and that has some type of race bias. That is also not something that is going to impact my decision, I think, as far as what I'm going to do in the case. I understand your position. Honestly, with the criminal history, which I know is another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially She even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So that's overruled. With regard to the fact that his prior convictions are inadmissible hearsay and too remote, in any motion to revoke probation or any case, prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's a driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were, understand the remoteness of some of these, but it doesn't take away from the fact that you have to have those prior driving while intoxicated to get where we are now. And so I'm going to overrule that objection with regard to the prior convictions. Any witnesses today by either party? Does anybody have any witnesses?
I have no additional witnesses, Your Honor.
Your Honor, we previously submitted letters of support.
Yes.
And we believe those are in the record and the court has reviewed those. I
Yes.
just wanted to note for purposes of today that we have filed those. They have been reviewed by the court, and we hope the court has taken those into consideration and considering sentencing as well.
Defense brings up letters of support, family, community, co-workers all vouching for him. And yes, judges do read these. They don't erase violations, but they humanize the person behind the record. In close calls, these letters can shave time off a sentence or keep someone on probation instead of behind bars. They're not evidence, they're empathy, and sometimes that matters.
I will, and I did, and let me pull them up again just because I think that's been.
So specifically, they were not admitted for this purpose. They were admitted for bond.
Okay, that's right. Thank
for
you.
purposes of bond.
Okay.
However, the letters of support, the
same,
information in
sure.
them speak to my client's character and
Yes.
his support by the community.
I see them right here, and I did review them obviously for that, and we'll take them into consideration for this hearing as well.
Thank you, Your Honor.
Anything else?
Your Honor, just in response to the analysis of the court's overruling of the objection.
Now the defense plays their strongest card. Time. From 2001 to 2018, no major issues. Then 5 years of clean probation, showing he can follow rules. They admit he messed up now, but argue it's one relapse, not a total failure. It's a solid argument, and honestly, you can feel the lawyer fighting for the guy's humanity here. Question for you. Would you give him one more chance or send him back?
We would point out, as noted in the PSR, there is a substantial time in between the prior conviction and the current one for which he's on probation. And we hope that the court was able to look at that and consider that from 2001 to 2018, there was a major gap. And then by all accounts, by the admission of the probation officer, Mr. Sanchez has had minimal violations, was not a supervision problem, made efforts to be in compliance with probation. And although he did plead true to the current violation, he has shown 5 years of continued compliance. And we ask the court consider the gap in history, the 5 years of compliance, as factors to keep him on probation.
Thank you, Mr. Franklin. Mr. Nichols?
Your Honor, this case was originally pled as an 8-year cap. I'd argued for Ben Diamond at its original sentencing 6 years ago. I'll acknowledge he's been mostly done well on probation except for the new offense.
The prosecutor steps in and plays it cool. He's not asking for the harshest time, just justice. He admits Sanchez behaved well for years, but another DWI while on probation? That's the line. So, he tells the judge, I trust your judgment, but probation isn't working. This is smart lawyering. It's not emotional. It's tactical. It shows confidence that the facts already speak for themselves.
And the new violations that allegedly did plead true to. And I agree that his criminal history, while somewhat extensive, is rather remote. So I think those factors give the court enough information to make a decision, I am in favor of revocation just because it is another DWI offense, Your Honor. But as far as the length of time, I think the court has enough information to make a just decision on that.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old.
And there it is. 7 years in state prison. The judge explains it perfectly. He had a long break, did well for a while, but then relapsed into drunk driving. Again. She even says, "We're lucky this isn't an intoxication manslaughter." That line hits hard. It shows how close DWI cases skate to tragedy. It's not about punishment alone. It's about protecting everyone else on the road.
But then again, you started it up again, in my opinion. You got this DWI, so you had, there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018, and now we have another DWI that you have admitted to in another county where you were driving a vehicle without the interlock and under the influence. And at this point, I feel like we're all lucky that you have not, that we're here on a DWI, not an intox assault or an intox manslaughter or something like that. At some point, you've got to figure it out. You're on probation for the same offense. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full 10. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation, but the main thing, you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you a trial court certification. I need y'all to sign this real quick, Mr. Franklin, that shows that this was not an agreement. So you do have some rights to appeal. Once y'all sign that, I'll get tear off that bottom copy for y'all if y'all sign at the bottom. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, then you can talk to Mr. Franklin. And I'm going to go back. I'm not sure if I'd said it exactly properly. I am going to reassess your punishment because you were already assessed a 10-year term. Reassess that punishment at 7 years. And here's that firearm, Mr. Franklin.
Thank you, Your Honor.
This is just going to go, this is to go in the pile after trial, yeah. Let's see. The bottom 2 copies are y'all's if you want to tear those off.
I think you pressed very hard, Judge.
That's okay, as long as my signature came through, I'm okay, because I get the top 2 with his on it. Give me one more of those. There's 4.
I'm so sorry.
Nope, you're good. Perfect. Thank you. All right, sir, you can go back with the bailiff. Good morning, sir. You're Alfredo Gayton. And Mr. Gayton was previously in court in cause number 25 DCCR 0184, entered a plea of guilty to driving while intoxicated third or more, which was enhanced to a second-degree felony because of prior offenses. The agreement was for a cap of 14 years in prison. I've received the pre-sentence report.
And now the final act, Alfredo Gayton. 4 prior prison terms, 7 DWIs, and a lifetime of addiction. But for once, the defense doesn't ask for leniency. They ask for help. They push for Safe P, a Texas rehab-style prison program for long-term addicts. The state's response? He needs help, but his record's too ugly. And then Gayton himself speaks, admitting he's been drinking since age 11. It's heartbreaking and brutally real.
Has everyone had an opportunity to review that report? Are there any additions or corrections?
No, no, Judge.
All right, Mr. Parker, you may proceed.
Just some of my client's knowledge, I've given the court and the prosecutor a letter of support from Frank Maida.
And I've received that and reviewed it as well.
And, Your Honor, from talking to this man, talking to people that have known him, he is a good person that's just an alcoholic. And I think he was, I think he was pretty honest in his PSI. He talks about drinking at the age of 11, then 14, and then get to the point where he drank, at least a 12-pack regularly. He drank tequila and Crown Royal regularly until the point where he passed out and could never get enough. He's had several DWIs in the past. He's never had any kind of help at all. And I think he is a prime candidate for safety to get the help. He's had some periods where he's tried to do it on his own, and he was somewhat successful. He cuts grass for a living for several people here in Beaumont. He has the ability to make money if he's given the opportunity to be put on probation and go to the safety program. So he can do that. It looks like to me that the PSI is also in concurrence that he would benefit from safety. And I just think that's the best thing for him instead of just locking him up.
Thank you, Mr. Parker. Ms. Malfino?
Judge, I think it goes without saying that he certainly could use the help of safety. I think it also has to go without saying that prior to the criminal history that cannot be ignored. Obviously, of course, we'll defer to whatever the court deems appropriate. I respect Mr. Maida's letter. I take him at his word. But it's just difficult for me to argue both ways because I think he needs the help, but I also think we have the criminal history to take into consideration.
And again, I think most of his criminal history is just drinking, and so many people have got the opportunity and it's worked for him, and he, not from anybody's fault, he's never got that help, It's okay. Is there anything you want to tell the court?
They sent me to prison and many work. They never faced me as drinking. I was looking for things. I'm always maintenance is to proceed. And I'm working on the freeways with Texas Department of Transportation, cleaning the roads, do anything. And disasters never give me a chance to stop.
But if you've gone to prison 3 prior times
Yes, ma'am.
for DWIs, 3 times you've gone to prison. So this is your 4th felony DWI.
Yes, ma'am.
This is at some point, when you get out of prison, do you say, I need help and I'm going to get help for myself instead of saying somebody else didn't help me?
I never had the chance. I have to look for work and.
But I know, but you have people like
Yes.
Attorney Maida. You could have said, hey, I need some help. You know people that can help me. I don't want to go back to prison.
Well, finally, this time I end up on the right city with the right people. Create a really good reputation. I met Mr. Maida, Dr. Suri, and a lot of good people, and they check my background, and Mr. Maida said my wife and me discuss, and we willing to give an opportunity. I've been working for them for years now.
We've got great news.
I just to make more clarity, I think that when he came here and he was working for the people around here, there were some things that he was doing and he was not drinking.
I don't remember the incident, but there was an episode where he started drinking again, and it was pretty close to the time frame of this. I'm not saying this is the only time, but he had started drinking again. And I don't take it that he was blaming anybody for not giving up. He just said he's never had that opportunity. And, when you're an alcoholic or a drug user or addicted to anything, it's easy for, to say, it's the same thing with an abused woman. Why don't you just leave? Why don't you just leave? Just learn.
But
Stop
if you,
drinking. And
but you
it's hard, yeah.
I don't disagree that it's hard.
And
But I also, if you'd never been to prison before.
right.
And if you hadn't had kind of the wake up call of prison to say, I don't want to go back to prison. I need to figure out how to stop drinking. And then you get out and then you do it again. Well, I didn't figure that out. Let me go
Right.
do it again. Your blood alcohol was 0.257. You ran off the road. You could have, there's just too many times that I see now, unfortunately, people in here where we're looking at someone who is, has killed someone or hurt someone. And the fact that this is
This judge doesn't sugarcoat it. She lists every DWI, 95, 2000, 2018, and now this. Back, 257. That's 3 times the legal limit. She says, you've been to prison 3 times already. When does it click? And then comes the warning shot. If she even considers probation, he'll never drive again. No interlock, no exceptions, just never. That's not punishment, that's prevention.
7th DWI. It's your 7th. I don't disagree that you need help, but I don't feel like now's the time for, and I don't know what happened in those cases in Harris County and Bexar County. If you were given an opportunity, at some point, I feel like there's opportunities for probation where people decide not to do that because sometimes doing a few years in prison is easier.
Well, I think
It's
some of
odd to me that there has not been a probation.
I think some of these, he sat in jail and wasn't able to bond out, and it's one of those deals, we'll plead you to 2 years or 4. I don't remember the numbers, and so.
You got 12 years back in 2004. 12 years for your DWI, second felony DWI. Then you got another one after that, and for some reason, Bexar County said, well, let's give them less time. Let's give them 5. Let's reward them for continuing the wrong behavior.
We've got great news for seniors.
Anything else?
The same thing. I just see people that, it's, I concentrate solely on the fact that his criminal history is alcohol. And there are people that we've seen on their 4th or 5th that we've given safety to, or people that are on probation. People are on probation for DWI and they violate the terms of probation by drinking, and they come back before, all these courts, and several times we say, hey, let's give you safety, and I can make the same argument, you just went to court, I get it, but I don't get what people think. But I just think he's a prime candidate for safety, and he would benefit from it. He's a good person. He'll work. But I understand the court's position.
Yeah, sure.
I've been so
I'm sorry?
I've been sober since the accident. I moved to Samoa.
You've been sober since the accident?
I moved to a chair that is on the back of the property, Mr. Maida, and he said one condition, no drinking. And I respect that, and I've been doing exactly what he says. Because I know he's the only one of the few persons that believe in me, and I see me a great opportunity. I know it's the chase of my life.
Slow down.
He said he's one of the only ones that will give him an opportunity. He knows he's serious about it. He's allowed him to move on the back of his property in a little room, I think.
We even went to what they call a retreat. He asked me if we willing to go, and I said yes, sir. And we spent 3 days. And he's a great person. He's been helping me,
So here's the thing, if I even were to consider, which I'm not sure why I'm even considering, but I might, giving you a probation, you would not drive ever a vehicle.
ma'am.
I mean, it would be part of your probation. So you're gonna have to, ever.
Get a car.
Listen to her.
I mean, it would be a condition of your probation that you never drive the entire time that you're on my probation. I mean, you understand that?
Yes, ma'am.
So,
Judge, if it would help the court, I'd be happy to try to get with the probation department and get with those other district attorney's office and see if there's ever been a probation on any of those cases that have been subsequently been violated.
I think they typically are listed in here that way. And so it doesn't appear that there ever has been one. I guess one of my dilemmas now is if I do consider probation, it would have to be a straight probation and only for the 10. And I lose that opportunity that I have today to give up to 14
Well, you could
years.
possibly, one thing we could possibly do is sentence him to 10 over 10, give him 180 days upfront and hold that in abeyance as a condition. I mean, which just extends it more. I mean,
Nah,
like
I don't know that it really extends the time. It just gives them time
Right.
potentially.
Yeah.
Okay, here's what I'm gonna do, Mr. Gayton. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to give you an opportunity today that you have not had, but there's going to be...
And just when everyone expects prison, she flips the script. 10 years in prison, suspended. Gayton gets probation, but with zero tolerance. 1 drink, 1 violation, and he's instantly serving the full 10 years. He must complete the Safe P program, go through JCDI aftercare, wear a scram ankle monitor, and pay fines. Oh, and he can't ever drive again. This isn't mercy, it's one last chance. And everyone in that courtroom knows it.
some conditions on this probation, and you will be on 0 tolerance. And what that means is that any violation, is going to get you right back in here with the sentence that I'm giving you today. I will make a notation. There will not be plea agreements on a motion to revoke your probation. If you violate, and I find that you violated, that's it. You're done. Do you understand? So I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You're on probation for 10 years. I'm going to order as a condition of your probation that you enter and successfully complete the Safe P program, and that when you're released as part of the aftercare, you will then enter and successfully complete the JCDI program, which is an outpatient program. You will be ordered not to drive any vehicle ever whatsoever. You will also be ordered to wear at all times a scram device. That's a device that will tell me if you have alcohol in your system. If you test positive on that, when you get out after Safe P and you test positive for alcohol, you will immediately be back in here and go into prison for 10 years. It's that simple. It's the length of time that you have been an alcoholic. This is going to be a very difficult process, but either you want to do it and go through that difficult process, or you want to spend the rest of your life in prison. So that's going to be up to you. There's no, I relapsed and this is a difficult thing, and I understand that. This is it. You will be ordered to serve 10 days upfront time as a condition of that program. That's required. You'll obviously get that time in while you're waiting to go to Safe P. Anything else condition-wise that anybody can think of? I'm sorry. I'm going to order a $500 fine All right, so I think that covers it. And so, Mr. Gayton, I hope you take advantage of this. It sounds like you're ready finally at this point in your life. I hope you take advantage of it because, again, this is the only opportunity you're going to get here in this court.
Thank you, I appreciate everything.
Have any ability to pretty tightly monitor his no driving? I mean, I know that's just.
I don't know how to, because if I put, a GPS won't do it because if he's in somebody else's vehicle, I mean, I'm inclined to reach out to,
Maybe some of those people who have reached out
yeah,
for him.
so I'm inclined to reach out to Mr. Maida and explain to him
I will explain to
about
him.
the no driving, because I know Mr. Maida is the one that helped get him that vehicle in the first
Right.
place that ended up, I think, part of this wreck.
3 cases, 3 lessons. Michael B. got a short sentence because he cooperated early. Juan Sanchez lost probation after crossing the line again. And Alfredo Gayton, somehow, walked out with one final shot at redemption. This is justice in real time, accountability, mercy, and risk, all colliding in one courtroom. If you found this as wild and eye-opening as we did, hit that like, drop your thoughts in the comments, and subscribe for more shocking real courtroom moments, where real people meet real consequences.
But when I say no driving, it doesn't mean in a couple of years I get some request that, hey, he's been doing great, let him drive. You're either riding with someone or you're on a bike or whatever else, or walking. And that is the most serious part of what I want and need to do to make sure that the community is safe. Do you understand?
Yes, ma'am.
Okay. I don't see the certification. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived the right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, Mr. Gayton. I hope you take advantage of this. Don't make me regret it, please. Okay.
Thank you.
I was gonna write it, but a BB gun. Now, a BB gun is considered a firearm. A BB gun and a pellet gun are considered firearms, believe it or not. And if you're caught shooting a BB gun or a pellet gun within the city limits where you live, and the cops pull up on you, they can take it away from you. They can also charge you for discharging a firearm in the city limits. Yeah, these guys, some of them get lucky, some of them, but like that guy said, this is real courts, real cases, and real consequences. So I'm gonna go ahead and call this one today, guys. Our mutual friend, Elemental P. Oops. All I can say is you need to watch Tug tonight. I believe Tug is going on tonight. You need to watch Tug. So I'm gonna go ahead and call this one for today. I broadcast every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern. I want to again thank all the new subscribers to this channel. Welcome, welcome, welcome. And thank you for supporting my channel. If you like this content and you are not a subscriber to this channel, please do me a big, big, big favor. Hit that subscribe button and hit all notifications. Help this channel grow. I want to grow this without promoting my channel on other YouTube channels, because you see what happened in the past. Yeah, Linda, one day I'm gonna have to call you because I want to talk to you about something. But yeah, I'm gonna go ahead and call this one. Ta-ta and ciao ciao. Have a good evening. I will see you guys tomorrow.